The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. This morning, we are going to be hearing the oral argument in the case of Jesse Vrew versus Iowa Department of Corrections and others. Before we get started, though, we're going to do something a little bit different. We have an audience. In addition to the people who are sitting here before us today, there are 4 separate high schools across the state of Iowa who are watching this. And I'd like to give them a little bit of a shout out. Hampton Dumont, Roland Story, Dallas Center Grimes, and Cedar Rapids, Washington. Welcome. We are happy to see so much participation for today. We are acknowledging Constitution Day, which is officially Friday, but we're acknowledging it all week. I'm going to do something a little bit different before I give a little comment on Constitution Day. And I'm going to start, and this is a little educational thing for the high school students. I am the Chief of the Supreme Court, and then to my right, and then to my left, and then you keep going in that direction until you reach the end, is the order of seniority on our court. And I'm going to ask each one to press their button and give their name and state which high school they graduated from. I'm Susie Christensen, and I graduated from Harlan High School.
Tom Waterman, and I graduated from Bettendorf High School.
Ed Mansfield, and I graduated from Lexington High School in Lexington, Massachusetts, where the Revolutionary War started.
For McDonald, I graduated from Des Moines Lincoln High School.
Dana Oxley, I graduated from Greenfield High School. Now I believe it's Nottoway Valley.
Matt McDermott, I graduated from Kemper Catholic in Carroll, Iowa.
Thank you. We don't do that ever, so thank you for indulging us. And I'm hoping that's a shout out to those kids in high school, that we too were all once in high school. And it's a very important process that we all go through. So officially, happy Constitution Day. I'm excited about Constitution Day because it's a day that we celebrate the document our court uses to guide us every day in our jobs as justices on the Iowa Supreme Court. You should be excited too. The Constitution is important to everyone, not just to judges. It is the foundation of our country's government. This is a day when we can all recognize the courage and great foresight of the authors of the supreme law of the land. Both the United States and the Iowa Constitutions define the individual rights and liberties of Iowans. It also establishes 3 independent and co-equal branches of government: legislative, executive, and judicial. It also explains the duties and responsibilities of each branch. It is a document that all 3 branches of government share as we do our work. All of us are bound by an oath to support the Constitution. Legislators refer to it as they discuss your issues and concerns, and then are careful to follow the Constitution when they create programs and policies. The executive branch follows the Constitution as its departments implement the programs and policies and enforce the laws. When a dispute comes to the judicial branch, the courts use the United States Constitution, the Iowa Constitution, and the laws passed by the Iowa legislature and signed by the governor to reach a resolution. The United States Constitution is the supreme law of the land, but a state, through its own constitution, may provide citizens with greater protection than the United States Constitution. When Iowans ask the Supreme Court to resolve a dispute, our decision is based strictly on the facts presented to the court and on the applicable law as reflected in our constitutions and state statutes. The rule of law ensures that judicial decisions are based upon our Constitution and our laws, not individual views, outside influences, or opinions of the day. The judicial branch of government can only perform its mission when courts impartially interpret and apply the United States and Iowa constitutions and our laws. Several months ago, a trial took place in Polk County and a verdict was rendered by a jury. Today, you are going to watch the oral argument of that appeal before the Iowa Supreme Court. Thank you for joining us today, and happy Constitution Day. Now we'll do what we normally do. I would like to do a bit of a sound check because we have several different players going here. We'll start with Mr. Hill. Would you do a sound check, please?
Testing, testing.
Thank you. Mr. Knight?
Testing, testing.
Thank you. And Ms. Hewlett?
Testing, testing.
Ms. Hewlett, will you be arguing from that podium?
Yes.
Thank you. Okay. Mr. Hill, when you're ready, you may begin.
May it please the court. My name is William Hill, and I'm an Assistant Attorney General for the state of Iowa, and I represent the appellants in this matter. This appeal follows a jury trial in Polk County in which the Iowa Department of Corrections, the Iowa Department of Administrative Services, and retired Warden Patty Wackendorf were found responsible for damages to Jessie Vrew, a former nurse at the Iowa Correctional Institution for Women, a prison located in Mitchellville, Iowa. Specifically, the jury had awarded emotional distress damages based upon the claims that she was not provided insurance coverage for certain transgender medical procedures and that he was discriminated against due to the claim that he was not allowed to use the men's bathroom. On appeal, there are two central issues. First, whether a new trial should have been granted based upon certain issues related to the jury instructions, as well as certain evidentiary issues which were raised in the trial. The second issue is whether or not there's a requirement to provide transgender medical procedures that are not part of a bargain for insurance coverage between the employer and the employee. The state of Iowa in this case, which is the Iowa Department of Administrative Services, the Department of Corrections, and Warden Wackendorf, assert that the trial court should be reversed on both issues. The initial starting point in this case is that Vrew came to the administration and the prison officials and indicated that he was transitioning to become a male. And so what happened initially was there was a conversation between an employer and an employee as to how to resolve this situation. The parties, specifically, and this is a contested point in the trial, was whether or not an agreement had been reached between the warden as a representative of the state and Jessie Vrew. The state contends that an agreement was reached. The agreement was that Vrew could use the unisex bathrooms located in the administration building of the prison. The plan was for him to use those bathrooms for a certain period of time. There was no requirement that Vrew use the female-only bathrooms, and essentially this was an accommodation between the state of Iowa and Vrew. Now, the key point is that the initial determination was not that Vrew had to use the female bathrooms, it's that there was an accommodation. And specifically to that end,
Mr. Hill, why is the accommodation fact relevant given the way the state's positioned its arguments on appeal? As I understand it, there is no claim that the state was entitled to judgment as a matter of law because of waiver or because this wasn't discriminatory conduct. The issues you're raising, at least on the substance, are jury instruction issues.
well, I think they relate back, the jury instructions issues, in the evidentiary issues, they all relate back to that accommodation. Because whether it's the business judgment rule or the same decision doctrine, the question was the prison officials allowed to make an accommodation in this case? In the trial court, in a way, the worded the jury instructions was that no, it's essentially the accommodation was no good. It was a per se rule that if Vrew was not allowed to use the bathroom of his choice, then it was discrimination. And that's the way the case was brought to trial. Whereas the evidence in this case was that there was an ongoing issue. Vrew had indicated that You wanted lockers in the bathroom, wanted a chair placed in there. There was an issue with regards to a particular employee who left a smell in the bathroom after he used it. And so the issue was not that it was a per se rule. It's essentially a case where Vrew indicated to the prison officials that he was transitioning. Transition means not only transition for Vrew, but transition for the staff of the prison. There's not a per se rule that indicates once an individual announces that they're transgendered, that there's a total unequivocal right to suddenly change. The prison had to make a decision. How do we deal with this? This is not a well-established decision in the state of Iowa or in society. This is a major question of which the courts and the legislature are going to have to deal with, the bathroom question. The prison did what they thought was best under the circumstances and do the accommodation. The accommodation that they thought best was to talk to Vrew and have this plan. Understandably, the plan was probably not the perfect plan. The bathrooms may not have been in the ideal location or whatever else. The point was that there was a plan.
Counsel, if I understand it right, you have at least two jury instruction claims.
Correct.
One is the same decision defense, and the other is, I think, independent business judgment. Where in the record does it state that, or who testifies that we would have made the same decision in this case if the sex of Vrew was different? Who says that?
I think the warden does.
Where? I mean, frankly, let me be very transparent.
Okay.
I don't see it in the record.
Okay.
I do see some history that you're describing.
Yes.
They did have some meetings. They did have some back and forth. But I didn't see the warden saying, well, we would have made the same decision anyway because of X, Y, and Z. And I didn't see the warden saying, well, it's not because of sex, it's because of the toilets aren't working, or there's some practical reason why Vrew can't have access. I didn't see that at all. What I did see in the record was the warden saying, well, we were concerned about the reaction of others.
Yeah, and that was one reason, and the district court shot us down and said that was cannot even be a factor. They
Right, but the
foreclosed
warden didn't offer another reason, I don't think. And if he did or she did, I'd like you to help me with the record.
Well, the decision was not, and I think you have to infer it, the decision by the warden was not to say, Vrew, you cannot use the male bathrooms. The decision by the warden was, here's an alternative that we've agreed upon. And I think that's the important thing. There was a meeting with the union representative in Vrew who said, hey, this is the plan. And so the plan was not to discriminate. If the plan would have been discriminate, they would have said, use the female bathroom of which your birth sex. That was not the case. It was something in between. And so that's the problem with the jury instructions in the whole tenor of the case, is that it was based upon this belief in the way that the trial court instructed it. It was as if the accommodation offered by the prison was not a factor to be considered. It was the trial court seemed to have a predetermination that there was discrimination, and if one were to read the jury instructions, it's almost as if they're directing the verdict against the state of Iowa unless they can come up with some super good reason that Vrew didn't get total unequivocal access to the restrooms of his choice on the date and time in which he made the request.
Mr. Hill, why is this a fact question or a business judgment rule question? It seems to me that your position is either the plaintiff was entitled to use one of the bathrooms or was not. And that seems to me to be a pure legal question and not a fact issue or jury instruction issue.
I understand the point, and I think that in the true nature of this case, if it would be continue to evolve, we would reach the juncture of this being the bathroom case. We're not there yet. We were not there yet. Rue was still transitioning. The prison was still transitioning. The problem that arose was a certain evidentiary issue that occurred during the course of the trial. Rue was terminated. And so if this case would have been allowed to continue and continue to fruition, the court, we would be here presumably, either the prison would have worked it out, they would have let Rue use the bathroom of his choice, or they wouldn't have, and we'd be here on what I call the true bathroom issue.
The thing is, as I understand this business judgment instruction, the concept it gets at is it tells the jury, even if you think the employer was unreasonable, that isn't necessarily discrimination. Right. You're kind of arguing for the opposite proposition. That is, even if it's discrimination, the employer was acting reasonably. What's the basis for that of an instruction in the civil rights law?
I think that the question in the business judgment rule was somehow, is it a pretext for discrimination? And what I think our argument is that it didn't reach the discrimination question because the parties thought they had an agreement. The law in certainly the court and the legislature will decide what is the law with regards to bathrooms, but in this case, the law was unclear. Basically, we did an accommodation. If this were a civil rights case, we'd be asking for qualified immunity because the law was not well established. And so I think in this particular case, it's the fact that an accommodation was made. Not that we're admitting that there was discrimination, because we hadn't reached that point yet. If the case would have been allowed to continue, we could have reached that point of where the prison could have said yay or nay. And so that's the point of the whole tenure of this case is it's premature. The case wasn't allowed to continue, and it wasn't allowed to continue because of certain evidentiary issues which happened in the trial. Mainly, Rue left too soon. Rue was terminated, and that's the evidentiary issues that kind of dovetail into this question.
But the bathroom claim was tried to the jury.
Correct.
So I guess I don't understand what you mean that there wasn't a bathroom claim, and I want to follow up with Justice Mansfield's question. What is the legitimate reason for requiring the plaintiff to use a different bathroom? It seems like what you're saying is this may have been discriminatory, and that's our business judgment under the circumstances presented. And as I understand it, the business judgment rule, the employer usually has to posit some legitimate non-discriminatory business reason for the decision.
In the legitimate non-discriminatory reason there was an accommodation between the parties. Rue was transitioning, the state of Iowa transitioned.
Yes, but counsel, let's say that this is race and not gender. I mean, does that change it? You know, in other words, if Rue were of a different race and he cut this similar deal that you say that he cut, would we be talking about a different situation?
No, I think it's the same thing. Well, race is a little bit different, and we don't have that here, but with regards to the sex of the offender and the accommodation that was made, I don't think, unless the court's going to come out in this case and say that there's a full unequivocal right to let all people in the state of Iowa use whatever bathroom they choose, I don't think that's the law yet.
But
I don't think that was the law at the time the case was tried.
Who's being accommodated in this fact pattern? You keep saying an accommodation. Who's being accommodated?
Rue was being accommodated by the offer to use the unisex bathroom.
What wasn't the accommodation to kind of placate or alleviate concerns of Rue's coworkers?
No, I don't think so. I think that was certainly part of it. The court specifically instructed against that, so I can't say that that was a consideration. And when you said that the case was tried on the fact that this was the bathroom case, it shouldn't have been tried on that fact. It should have been tried on the factual question. Jury instruction number one, or how we had it in the proposed was, was there an agreement between the parties? The jury could have said yes or no, and if they would have said, nope, there was no agreement between the parties, we'd certainly have a tougher case here before the court today. But the point...
Counsel, didn't the jury reject the argument that there was an agreement that Brew agreed to only use the unisex bathroom?
I don't think they were instructed on that. It wasn't...
Did you ask for an
Yes,
instruction on
yes.
that? All right.
Proposed instruction 15A.
Okay.
So that's what we asked for, and we wanted the accommodate, because otherwise, if it's just a trial between, otherwise, and that's the argument that we had before the court, the way that the jury instructions were worded were, well, jury, you have to rule for the plaintiff unless the state can come up with a good reason, and oh, by the way, a good reason isn't what other people think. It isn't whatever justification the state has, and there pretty much is no justification.
Isn't that right? I mean, the fact that others may have viewpoints, I mean, let's take race as an example. Some people might say, well, I don't want to associate with people of a certain race. That doesn't cut it, I take it.
That probably doesn't cut it.
Probably,
But that doesn't
probably. I mean, it surely doesn't cut it. And the same would be true for sex. I don't want to associate with a certain sex. If people said that in the workplace, the employer couldn't rely on that, right?
Right, but remember...
On gender identity for the same discriminatory purpose.
Okay. I understand the question. And remember, the actions of Rue and the actions of the warden are not in isolation to each other. There are other staffs, there are inmates. This is a maximum security prison. The warden has more concerns over what's going on. Remember, in the prison, there's a failure to protect. She was likely worried we do have sexual discrimination in the prison. What are people going to say or do to Rue? What can they do? Do we need training? Do we need other issues to transition the staff to such a plan? And that's essentially why the jury verdict should be reversed, is that argument was not allowed to be made.
Thank you. I believe Mr. Knight is going to go first, and you and Ms. Bettis Austin are going to share your time.
That's right.
I'll
Your
let you
Honor.
two be the judge of that split.
Yes, we will do our best. I may get nudged. May it please the court. My name is John Knight, and I, along with Rita Bettis Austin, represent the plaintiff, Jesse Vrew, in this case. I will take about 12 minutes to respond to the state's argument, and then Ms. Bettis Austin will present our arguments with respect to the liability of Wexford. This is one of those rare cases, Your Honors, where there were not fact disputes. There was no fact dispute over the fact that our client was told he could not use the men's restroom because he's transgender. There were no fact disputes, over whether over his being denied access to gender-affirming surgery, again, because he's transgender. The state's actions were not much different than putting up a sign and saying, on the restrooms and locker rooms, and saying no transgender people allowed. And similarly, when it comes to the insurance policy, it provided that medically necessary surgery was available unless you're transgender. Counsel said in argument that this was not that this was just a exclusion of coverage and that there were other exclusions of coverage. But the difference is that this exclusion of coverage only applied to transgender individuals. It was an exclusion of coverage for treatment of gender dysphoria, although the language was gender identity disorder in the policy, and of gender transition surgery, applied only to transgender individuals. The undisputed evidence showed that surgery was provided for the same procedures, breast reduction surgery for other provisions, for other kinds of conditions, but not for this particular condition, a condition that is only experienced by transgender individuals. Because there were no uncontested facts over the liability issues, the state was simply not entitled to either a business judgment or a same decision instruction. Warden Wachtendorf said, and the only reason she would give was that she was denying Mr. Vrew use of the men's restroom because she was balancing concerns from other staff. She offered no other reason. She was asked repeatedly. She said, I can't give you A, B, C, D. Never offered any other reason. When asked to name the individual who complained, she gave one name, Chris Wolf, but Mr. Wolf testified that he never complained about Mr. Vrew's being able to use the men's restroom. As a result, the court need not address the question of whether employee discomfort is a defense. However, it can't be a defense. To allow such a defense would completely undermine the enforcement of civil rights laws, as many courts have found in a number of decisions outside of Iowa, including from the U.S. Supreme Court.
Counsel, if we conclude on the statutory argument that there's a distinction between the terms sex and gender identity within the meaning of the ICRA, was it erroneous for the district court to give the jury instruction on sex discrimination?
We believe that it is true under Summers, this court's 1983 decision, that the court drew that kind of a distinction and found that transgender people were not covered. But we think that the analysis that courts have applied, including this court, of interpreting sex to include gender-based discrimination or the enforcement of gender stereotypes would apply, and therefore it was proper to instruct the jury as to the sex discrimination provision as well as the gender identity.
Assuming that we continue to hold there is a distinction between those two terms within the meaning of the statute, was it erroneous to give the sex discrimination instruction to this jury?
No, Your Honor. As was found in the Bostic decision, the fact that there is a distinction between the broader term sex and the more narrow term gender identity does not mean that both cannot apply. There can be overlapping coverage, which is certainly true for other aspects of the Civil Rights Act. Race and color are both described and both are covered in many instances. Race and creed are covered in the Civil Rights Act. Both could apply, doesn't make one superfluous, doesn't mean that the court...
Counsel, the fact that both could apply, why was there two separate instructions and two separate claims then presented to the jury? My question is, were you seeking different damages for each of those claims, or was there overlap, or were they essentially the same claim?
They were effectively the same claim, and it was the same damages applicable, but both should apply. And in protection of our client, we certainly believe that both should apply here, as in this court's DeBoom decision, where the court found that both the pregnancy provision and the sex discrimination could apply to determine that the woman in that particular case was facing discrimination after pregnancy.
Yeah, could.
Agree with you. Does it make any difference if both gender identity and sex discrimination were submitted same claim for the same act, same damages? What's the remedy? You still get the damages under gender identity.
That's right, Your Honor. The fact that the state has not appealed the gender identity finding would mean that there's certainly no prejudice here. If the court were to reverse on the sex discrimination, the same damages would apply.
But counsel, doesn't the verdict form have both sex and gender on it? In other words, it doesn't separate them, does it?
It does not.
So what can we do with that?
And sorry, let me correct that. It did separate that, I believe, with respect to the health insurance provision. I think you may be right that it didn't separate them with respect to the restroom access. I don't think that. I think ultimately the state is not prejudiced because the jury could have found both, and both would. This court should affirm on even if it were to find that it was improper to instruct with respect to the sex discrimination provision.
So what is the sex discrimination claim specifically that is distinct, that is wholly distinct from gender identity discrimination. Could you explain that to me?
As the U.S. Supreme Court found in the Bostic decision, you can't, and as this court has found in De Boom, you don't have to show that it's the sole cause, and certainly when someone is discriminated against because they're transgender, sex is a necessary but-for cause of the discrimination. That was certainly true here. So you could not have denied Mr. Vrew access to the restroom without taking into account the fact that his sex assigned at birth was female, not male. Had his sex assigned at birth been female, he would have been given access to the male restroom like everyone else.
But counsel, in Bostock, they were dealing with Title VII, which doesn't include the word gender specifically, whereas the ICRA does. Does that make this different than Bostock?
It does not, and there are a number of courts that have looked at both the gender identity and the sex discrimination provision. I believe we cited a Connecticut district court case where Connecticut law protected against gender identity discrimination, and the plaintiff there had sued under both the sex and the gender identity provisions, and the court found that both applied. So we think that the jury was properly instructed under both. Just want to make sure.
Could you respond to your opposing counsel's argument that the jury should have been instructed about this alleged settlement agreement or agreed accommodation and proposed instruction 15A?
First of all, Your Honor, I don't think that plaintiff could, well, the jury was offered evidence, and the argument was made certainly by the state that this was an agreement. But the evidence showed otherwise. The evidence showed very clearly that Mr. Vrew was in agreement to this because the state was going to put in place a policy, and yet he made clear from the very beginning that he wanted to be able to use the men's restroom. That's what his doctor had recommended. And he continually asked. Warden Wachtendorf got emails from Mr. Vrew's immediate supervisor asking Warden Wachtendorf, what do I do about the fact that Jesse Vrew continues to ask, when is the policy coming out? When is he going to be able to use the men's restroom? And so it was certainly not an agreement. The jury saw that there was this, to the extent there was a dispute. I honestly can't see how it was really a clear dispute, because Warden Wachtendorf agreed that she never allowed Mr. Vrew to use the men's restroom or locker rooms, and that she agreed that she'd been asked. We just don't think that the evidence supports that. As I've said earlier, I think that neither the same decision instruction nor the same business judgment instruction are applicable here or should have been provided, because instructions should only be provided where there's evidence to support them. The only evidence that was offered, or the only reason it was given with respect to the restrooms.
Counsel?
Yes.
Is the lack of evidence the only reason that the business judgment rule should not have been instructed? If there had been evidence that there was some type of an agreement, would that be a basis for offering or for providing that instruction to the jury?
I'm not seeing that would have been a reason for giving the business judgment instruction, but the district court carefully considered all the arguments that were made at the time and determined that it was not an applicable instruction, that the evidence did not support it, that the only reason, and when Warden Wachtendorf was asked the reason, that's not a reason she gave. She never offered this as a reason for why Mr. Vrew was denied use of the men's restroom. This agreement was something that came out at trial but was never offered at the time. In her testimony at trial, she never offered it. She asked, what are the other reasons? I can't give you A, B, C, D, she said. The only reason she came up with was balancing other employees' concerns, that is not a non-discriminatory reason, and it not only must be an articulable reason, but it needs to be a non-discriminatory reason to be entitled to that instruction. I see my time is up. Thank you, Your Honors.
Ms. Bettis Austin.
Thank you, Your Honor, and may it please the court. Wellmark denied insurance coverage to my client for his medically necessary mastectomy for one reason, because he's transgender. Wellmark has never disputed that the underlying exclusion in this case was discriminatory. Instead, it argues that under ICRA, because it's a third-party administrator, it cannot be liable as a matter of law, no matter how discriminatory the plan was. Wellmark would like this court to read an exception into the Iowa Civil Rights Act for third-party administrators, even when, as here, it was directly, heavily involved in the underlying discrimination and had the ability to effectuate it, meeting the test that this court just set out in the Rumsey decision a few months ago. It wants immunity, both to suggest, to actually draft facially discriminatory coverage and to agree to administer facially discriminatory coverage. Whether we're talking about coverage that discriminates facially on the basis of gender identity and sex, like here, or on a different basis, like religion or race.
Counsel, what damages would only be available from Wellmark that you could not have sought from the state?
Well, I would just say, under the theory of joint and several liability that we are proceeding under, that we think is applicable to the analysis, under any of the three theories that we're arguing, that we don't need to identify damages that we could not have sought as against the state, that we're able to pursue those damages against either of the co-defendants.
You chose to narrow your damage claims against the state to emotional distress. The jury awarded a verdict. We have a one satisfaction rule. You can't get double recovery. Do you agree that emotional distress is now resolved, that you couldn't, even if we remanded against Wellmark, you couldn't sue Wellmark for emotional distress to get more, right?
Well, as you noted, we also have out-of-pocket compensatory damages that we didn't seek and didn't get from the state, but we think
Why not? Why did you hold those back on your trial against the state?
Well, I'll say we pursued those damages as against both Wellmark and the state. Wellmark was dismissed on summary judgment. We believe erroneously, that's why we're here. And we reserved some of those damages. And I believe it
But
would
under res judicata or claim preclusion, if you could have recovered them from the state, I mean, you don't get a second bite at the apple.
Well, I would argue that this is the first bite at the apple because we have not been able to pursue our full damages as against both Wellmark and the state because Wellmark was dismissed on summary
And what
judgment.
are those additional damages specifically?
So in this case, we have some compensatory damages that are related to my client's out-of-pocket expenses as a result of not being able to get the insurance coverage at the time that it was denied under the state and Wellmark plan. And so there's just a bit over $2,000 of out-of-pocket expenses. We also think,
Any legal reason you could not have sought to recover those in the jury trial against the state?
well, we actually didn't have the full extent of the damages at the time that we had the trial against the state, I believe, because the insurance claim for my client's surgery was not resolved until well after the trial, actually.
Yeah, a lot of times there are, claims for future medical expenses in trials. Any other reason?
Well, I would just say that we also think that we should be able to pursue additional emotional distress damages as against Wellmark for Wellmark's role, which the jury was not able to consider in our case against the state. And actually, that was for good reason, so that the jury wouldn't be confused about the role of a non-party in the trial.
Who would be legally responsible for actual payment of the medical expenses under this contract? How would that work out in the real world?
Well, this is a self-funded plan, as Your Honor knows, and so what that means is that the employer ultimately pays the claims, and Wellmark agrees to administer the claims.
So what would happen if Wellmark authorized medical services under the contract that doesn't allow for it? How does that play out as between Wellmark, the state, and the hospital?
Your Honor, we know how that plays out because in this case, despite Wellmark pointing to this exclusion under the mental health services, that it claims implicitly barred coverage for all transgender-related services just prior to the addition that it suggested in the 2015 plan, Wellmark actually paid for my client's medically necessary hormones and hormone labs, which were for the purpose to treat gender dysphoria. So the record shows a material dispute of facts on this question of the amount of discretion that Wellmark had in administering claims. And if you look to the master service agreement, which Wellmark cites to, because there's a provision in the master service agreement that says there is no agency relationship. And in our brief, we point out that's not the test for agency relationship. You have to look at all the facts. But there's another part of the master service agreement. It's section 5.13, and it specifically provides that Wellmark is given discretion not only to suggest the plan documents, the redlining it does each year, but to administer the claims and the appeals, and that it's the final word on those subjects. So I think we know the answer to Your Honor's question, which is that there was a fair amount of discretion in practice in how these claims were covered.
But Wellmark comes back and says the what I'll call the fundamental policy decision to exclude this kind of surgery was made by the state. And if I can recharacterize their position, it's that, you know, whatever the state wanted, we would have provided. If the state said $10 in coverage, you got $10 in coverage. If it said $8, it got $8. If it said cover the surgery, they got it. So Wellmark says, look, we just wore the green eye shades. We just did the technical stuff. If that were true, wouldn't it be like the Deeds case where the third party really didn't have decision-making responsibility?
No, Your Honor. So the test that this, I mean, I think Deeds is under an agency theory, and we brought agency in addition to direct liability and aiding and abetting liability. And I think the analysis is probably different. But this court just identified what the test is in Rumsey as to liability as a person and aider and abetter liability. And that is direct involvement in the underlying employment discrimination, which they had here. They suggested the discriminatory exclusion. They suggested all of the coverage terms every year and the ability to effectuate. And they had that here too, because they agreed to administer the plan. They in fact did administer the plan. They did so with discretion.
I'm going back to Deeds. I mean, in Deeds, there was a suggestion that the applicant was not medically qualified to be a firefighter. Suggestions arguably don't give rise to liability, or do they?
Well, in this case, we're not talking about independent medical advice that is either not under the control of the employer, which was the analysis under agency in Deeds. Here, Wellmark is actually saying that it was under the control of the state. So it's actually conceding an agency relationship, even as it's disputing liability as a person and under aider and abetter liability, sort of analytically. But
You may wrap up that answer.
thank you, Your Honor. But I would just say that the difference between this case and Deeds is that ability to administer the high degree of discretion and the reliance that the state put on Wellmark every year, and in this instance, in order to design the discriminatory exclusion at issue. And with that, I will sum up. Thank you, Your Honor.
Thank you. We're not going to leave the bench, but we're going to just say goodbye to the high school kids. They are going to be signing out at this time. Thank you very much for participating. This hearing is not yet over, but we understand you have another class to go to. So we'll allow another couple seconds there. I don't think anything has to be done on our end. So if everyone's ready, Ms. Hewlett, on behalf of Wellmark, you may begin when you are ready.
May it please the court, counsel, my name is Deborah Hewlett, and I represent the Cross Appellee Wellmark. Your Honors, this cross appeal arises from a claim administration decision. The denial of the plaintiff's prior approval request was based on an exclusion in the state's self-funded health benefit plan, the terms of which the state was solely responsible for establishing and approving. The question presented.
Ms. Hewlett, is there evidence in the record to support Ms. Bettis's statement that Wellmark would have had discretion to waive the exclusion and to allow this mastectomy surgery to be covered?
There's no evidence in the record. Wellmark did not have discretion to approve a procedure that was expressly excluded in the plan. Wellmark had some discretion in making medical necessity determinations because that's necessarily not always a black and white determination. But medical necessity was never at issue in this claim because the procedure that was requested was simply not covered under the terms of the plan. And Wellmark did not have discretion to approve a procedure under the state's self-funded plan that the state had chosen to exclude.
Counsel, why isn't this a fact question?
Because the facts are undisputed, there are no facts that show Wellmark had the ability to effectuate the adverse employment action if you're speaking to the terms of the self-funded plan and the exclusion that is at issue here. As for the claim administration decision, that was truly a decision that is not an employment practice. That was a decision performing contractual services as a third-party administrator based on the terms of a plan that the state established and approved. And so as to the policy language, and I should correct this. I've heard discussions about insurance. This was not an insurance policy. This was a self-funded benefit plan that the state established. There was no insurance paid by Wellmark at all on this plan.
Ms. Hewlett, is there evidence that Wellmark was more of a principal in directing the state how to craft its benefits plan, that they were advising on what the exclusions should be?
There is not. When this master services agreement started effective January 1, 2013, Wellmark's direction based on the state's RFP to applicants was that the plan should be structured for coverage terms to have what the prior plan had, and that is what Wellmark did. The prior plan had an exclusion for gender identity disorders, and so the 2013 plan did as well.
Well, but, correct me, of course, but the prior plan had an exclusion for counseling. It didn't have an exclusion for medically necessary surgery. And if I understand the record right, and please, I'm inviting help here. Wellmark proposed, well, if we have an exclusion for counseling related to transgender issues, that implies that we should have an exception for transgender surgery. Am I right so far? Is that a fair characterization of the record, or
That is not a fair characterization
okay,
of the
fix
record.
it for me, please, yeah.
One state employee with Department of Administrative Services testified that services regarding transgender-related care were excluded from the state's health plan in 2006 when he started working for the state.
Was there a provision in the plan that expressly excluded in 2006?
We don't have the plan from 2006. This state employee was responsible for the employee benefit plans, and he testified, I started in 2006, and transgender-related care was excluded from the state's plan. That's in Appendix 1273. He said that exclusion continued until 2017 when it was removed. Wellmark's medical director also testified that the state did not have coverage for gender dysphoria-related treatment as far back as 2007. That's at the confidential appendix, pages 57 through 58. Now, there was an additional clarifying language added in 2015 That is when the language gender reassignment surgery was specifically excluded in addition to treatment for gender identity disorders. But that did not add an exclusion. That clarified an existing exclusion. It didn't change how Wellmark administered claims under the exclusion, and that's at Confidential Appendix 59, 63, and 397. The condition, gender identity disorders, was excluded since at least 2006. The benefits booklet expressly stated, because they can't craft a benefits booklet that identifies every single procedure that's excluded, but it would clearly excluded treatment for the condition gender identity disorder. And the benefits booklet stated, even if a service is not specifically described as being excluded, it might not be covered. And that was intended to cover situations where there are more things, more treatments or procedures possible than what is specifically identified in the benefits booklet. But the condition was excluded since at least 2006. And there's no factual dispute on this record that the Department of Administrative Services was the plan sponsor, plan administrator. The state was solely responsible for establishing and approving the plan's covered services and exclusions. This master services agreement obligated Wellmark to provide the state draft benefit documents, but that was for the state's review and approval. The drafts had to set forth the benefits, terms, and conditions of the plan as determined by the state and communicated to Wellmark. The master services agreement also established the state was responsible for compliance with all applicable laws. The state was also responsible for determining that the benefits booklets meet its legal obligations, and the state was...
Counsel, can you address our recent Rumsey case and whether or not Wellmark's suggestions or recommendations to the state would meet the effectuate or the ability to effectuate that we discussed in that case?
Well, there is no ability to effectuate without decision-making authority, and Wellmark had no decision-making authority here. And additionally, in the Rumsey case, the court observed that serving in an advisory role without more is insufficient to support liability. So at most, the draft benefit booklets that are being referenced were advisory, and that's not enough to establish liability. State employees...
Counsel, even if there's a fact question, are the claims against Wellmark moot after the jury verdict against the state?
Absolutely. As we've articulated in our motion to dismiss based on mootness, I think the jury instructions that the plaintiff requested at trial on the denial of benefits claim are law of the case as to the plaintiff. And so that's what plaintiff asked for. And hypothetically, if this was to be sent back to trial, I don't think the plaintiff could request any different instructions on that health benefits claim.
Well, Wellmark was out of the case at that point. Is there some theory that would have allowed Rue to seek different or additional emotional distress damages against your client?
No, in fact, in the plaintiff's pleadings, the plaintiff pleaded joint and several liability between Wellmark and the state defendants as to the health benefits claim.
What about the additional out-of-pocket expenses?
Plaintiff didn't request them at trial in the first time, and the plaintiff doesn't get a second bite at the apple.
What about attorney's fees against another joint and several?
The same thing applies, and those aren't an element of the plaintiff's damages. That's a remedy, and the remedies don't apply because the claim is moot.
Injunctive relief?
There is no injunctive relief. The plaintiff didn't request injunctive relief against the state. And in fact, the injunctive relief was dismissed in a motion to dismiss early on in the case because the 2017 plan removed the exclusion and there was nothing left to enjoin.
Does our decision in De Dios come into play here where we held, we declined to recognize a cause of action against a claims administrator in a workers' compensation policy?
I believe that could apply. The plaintiff hasn't pleaded it, and the plaintiff pleaded only an Iowa Civil Rights Act claim. Here, Wellmark was simply administering claims pursuant to its contractual obligations, and it didn't have the discretion or ability to deviate from the terms of the plan. Under the Master Services Agreement, Wellmark was obligated to make benefit determinations and process claims in accordance with the plan and the benefit documents. Thus, as to the claim administration activities, I don't believe that falls within the scope of what an employment practice is under the Iowa Civil Rights Act, but even if it does, Wellmark did not have the ability to effectuate a different result. The plan said that this was excluded, and therefore Wellmark could not have approved the pre-approval request.
Does Wellmark have any independent duty to police whether or not the proposed plan or benefits plan is lawful?
Not under the employment practices provision of the Iowa Civil Rights Act.
So at least under the ICRA, so let's assume you had an employer that decided it would not provide employment or medical benefits to certain ethnic minorities because they historically have higher claim rates. Are you saying that your position is that would be okay for Wellmark to sign that master services agreement and administer that contract?
Well, Wellmark hasn't had a client do that, so it's hard to speculate about what would happen if that
But legally, is it your
occurred.
position that Wellmark would have no duty to avoid entering in that contract and would have no liability for administering a contract that had an express exclusion for ethnic minorities?
The Affordable Care Act, under the Affordable Care Act, there are obligations on all parties, and so Wellmark certainly made the state aware of the non-discrimination provision under the Affordable Care Act after the final rule came out in 2016, which ultimately led the state to decide to change their plan.
Well, let me ask this question.
Back to my hypothetical, okay? I mean, it's a pretty easy yes or no question. Your position is, as a matter of law, Wellmark has absolutely no responsibility under the ICRA for any of the plans it administers. Is that correct?
Wellmark doesn't have responsibility to review the plans from an employment practices perspective and determine whether there's an unlawful employment practice that the employer client is engaging in. I want to briefly address the 216-6A claim and just note that Wellmark was not a proper party defendant to that claim. The statutory language refers to an employer or agent of any employer. Wellmark was not the plaintiff's employer, and Wellmark was not, there's no evidence to show that Wellmark was an agent of the plaintiff's employer, the Iowa Department of Corrections. So the district court made no error of law in granting Wellmark's summary judgment on that claim.
Don't we have a lot of cases that agency is generally a question of fact?
Well, as to the 216-6 claim, I think the agency analysis is no different than the person analysis, and trying to, whether it's agency or person, I think the same analysis in Rumsey would apply. So it does, I'm not sure that it matters if you try to characterize Wellmark under 216-6 as an agent or a person. The same legal analysis applies, and there are no factual disputes that could establish that Wellmark had the ability to effectuate the adverse employment action. At most, as to the plan's terms, Wellmark served an advisory role. But the state, the evidence is undisputed that the state is the entity that determined the benefits. I want to also go back to the Master Services Agreement. Not only was the state responsible for establishing the terms of the plan, but there was an additional level of approval required from the state because the Master Services Agreement required that the Iowa Insurance Division approve the terms of the plan. The state, not Wellmark, had the ability to change the plan's terms at any time or to make claim exceptions. And the record shows that Wellmark did contact the state about this particular claim to see if the state wanted to make an exception. Since 2013, Wellmark has had an internal medical policy for gender reassignment that is designed to provide coverage for gender reassignment treatment or procedures for plans that want to add it. And so because Wellmark could not make exceptions to the plan, a Walmart representative did contact the state in 2015 twice to communicate information about that internal medical policy, which was actually available to the public on Walmart's website. A Walmart representative contacted the state about that in June 2015 and again in November 2015 about the plaintiff's claim. And to conclude, we ask the court to dismiss this cross appeal as moot or in the alternative to affirm the district court's decision granting summary judgment in Walmart's favor. Thank you.
Thank you. Mr. Hill?
May it please the court, this case was a complicated case in terms of both the factual, legal, and evidentiary issues. And one of the issues that was raised in this case was certain evidentiary decisions that were made by the trial court with respect to the plaintiff. Specifically, this case, as indicated in the opening argument, it was a process ongoing. And the process that was ongoing that would have presented kind of the full picture of what probably could or should have happened was cut early because Vrew was terminated. And the evidence of Vrew's termination was not allowed to be presented to the jury. It's position of the state that that evidence would have been important in terms of credibility because, as in this case, the damages were primarily or exclusively emotional distress. The reason for the termination itself was not due to like a more generic reason, but it was due to the fact that Vrew had copied confidential medical records and sent them to an outside party. And that's the problem. I know that there's the counter argument that, well, Vrew ultimately received unemployment benefits. That's not the determinative factor. Vrew applied to get her job back, to get it reinstated, was denied. That's an important factor in terms of Vrew's emotional damages that they may have had, and also the motivation for a lot of the case, because there were other factual issues raised in the case that indicated the true motives, the true damages with respect to Vrew. That is, there were some Facebook posts or postings.
Here's my problem with that stuff. I'm sorry, Mr. Hill, it's me.
Okay.
So here's my problem with that. I can see the argument that, these statements about wanting, Wachtendorf's head on a platter and all that might be relevant to the degree of emotional distress suffered by Vrew and might be used to undermine some of Vrew's testimony about the degree of emotional distress he suffered. Having said that, they're also prejudicial and also things that could be used improperly because typically motive is not relevant. Typically, the fact that somebody has been fired after the events that give rise to the lawsuit for unrelated reasons, those are normally things that might not normally come in. So why isn't this just an abuse of discretion call? Judge Rosenberg made it. It's done. It's over.
Well, first, if it was an abuse of discretion call, I think he abused his discretion because credibility was so key in this case in terms of Vrew. Was there the agreement, the accommodation? Did he agree to these or did he not agree? There are issues underpinning that as well as the damages. They go to the level of damages. Was there emotional distress if he claimed that he was going to take the money and go to Florida and Disneyland for a vacation? These are important evidentiary questions that the jury should have heard about with respect to Vrew, and not just the motives, but the credibility of what was going on. And I think in every case, the ultimate question that the jury is going to decide whether to hold for Vrew or for the state or any party is the credibility. And in order to decide the credibility, they have to get the full picture, not just one side of the picture. And that's the position of the state, is that this evidence should have been allowed to proceed. I would also be remiss if I did not talk about the insurance issue in this case, because one of the elements of the claim was that emotional distress damages were awarded against the Iowa Department of Administrative Services for not including in a negotiated agreement with the bargaining unit the claim for certain transgender procedures. The position of the state is that the agreement for insurance benefits was a negotiation. For whatever reason, the parties did not place such a term in there in this particular time frame. It was in the very next time frame.
Well, but counsel, that wasn't Mr. Vrew. That was the union, right?
Correct. That was the union could have raised it. The union could have said, hey, this is unfair that you're discriminating against. This would have been a claim for them to raise. Essentially, if the claim of Vrew in this particular case is an E&O claim to the union because they forgot to put in this important coverage.
You may wrap up.
Oh, I apologize. The state in this case asserts that the jury instructions as well as the evidentiary issues and the other issues related to damages are not supported by law or fact and should be reversed.
Thank you. And I'm not sure which one, Bettis Austin or Knight. I fear you'll choose. Thank you.
Thank you, Your Honor. I will begin where this court did in its questions to Wellmark and address the evidence in the record of discretion. I think there are two main places to look. One is the plain language of the MSA itself, Section 5.13. In that MSA, specifically delegates to Wellmark claims administration and appeals, as well as drafting those plan documents, and it gives it not only discretion, but really the final word in those matters. And then I wanted to provide the appendix citations for the evidence that Wellmark, in fact, did cover Vrew's hormone treatments and hormone labs, which were also to treat his gender dysphoria, demonstrating either or both of two things. One, either that it had quite a bit more discretion than it says that it had, or that, in fact, that mental health services exclusion that it points to say that the addition of gender-affirming surgery as an exclusion to the plan was of no consequence. Those things cannot be true. And those citations are confidential appendix 75 through 76, confidential appendix 524 through 525 and 557. And then Wellmark introduced this evidence that it had paid the claim for the hormone labs as Exhibit 5, or actually probably Exhibit V, which was filed under seal November 21st, 2018. I don't know if that is in the appendix or not because it was filed under seal.
Well, let me ask you some follow-up questions. We had some discussion about the history of the plan going back, I think, to 2006. And the suggestion was that there was testimony in the record that as of 2006, transgender medical services were not included, and that they've never been included. I mean, you heard the testimony. And then secondly, the suggestion was, well, even in this particular case, the decision was served up to the state, that Wellmark contacted the state and said, hey, you know, basically, what do you want to do? If those two facts are true, namely that the state has always excluded transgender services, and two, in this particular case, the state was given the opportunity to say, oh, pay it, don't you lose?
Well, Your Honor, those are disputed facts. They're not undisputed facts. So the plain language of the plans themselves show that the exclusion for gender-affirming surgery was not present until it was added at Wellmark's suggestion.
Well, it wasn't present apparently in the documentation, because we don't have a document, if I understand it right, from 2006.
Well, we have the plan documents from prior to 2015. All of the plan documents do not have the exclusion for gender-affirming surgery, which is the procedure that is at the basis of this claim. There is an exclusion for under mental health services for gender-affirming counseling, therapy. The jury is absolutely free to rely on its common sense in deciding whether or not surgery is a mental health service, but the plain languages of the plans, as well as the fact that Wellmark, despite that exclusion, was covering other non-mental health services like these hormone labs,
Well, I think
all
that-
create a disputed fact.
I think the suggestion is, well, look, it expressly excludes counseling services. And that implies that transgender surgery is excluded. And so we're just clarifying existing policy.
That is a disputed fact, and Dr. Gutschall, who provided that testimony, is an interested witness, and the jury is free to disbelieve him based on the plan language itself, as well as the other facts that I've pointed this court to.
Counsel, over here. Sorry.
Oh, thank
So
you.
at summary judgment, though, you had an obligation to present evidence to support that as a disputed fact. What evidence did you present at summary judgment that identified whether or not coverage was provided back in 2006 or 2007 to contradict that undisputed fact?
Two things. We pointed to the plain language of the plans themselves, and Wellmark introduced on its own the evidence that it paid for my client's hormone lab. So we didn't need to introduce that into the record because Wellmark did.
Their argument with respect to the exclusions is they were kind of duplicative, which is kind of like your argument with respect to the having both gender identity and sex in the Civil Rights Act, right? I mean, aren't you kind of making both the same type of argument?
Madam Chief Justice, may I respond? I see I'm
Yes, you may.
out of time.
Thank you.
Thank you. So no, these are entirely different. One is a matter of statutory interpretation about a boots and suspenders approach to coverage as a remedial measure in non-discrimination law. And the other is a factual question for the jury about what this exclusion under mental health services actually excluded. But I'll say that the opposite formulation actually applies, because if you look at the plan document itself, it makes clear that surgery is covered when it's medically necessary. And until 2015, there is no exclusion. That language that Wellmark points to in the plan document that says not every claim that is not specifically provided here may be covered could mean any number of things. For example, there are lifetime caps on coverage. Wellmark could determine that a claim that is included was not medically necessary in a particular case. It just doesn't say all that they are claiming that it does for legal purposes in this case. But this question of ultimate decision-making authority is one that this court rejected as the standard in Rumsey. That was expressly laid out in that case. So that's not the standard. We don't have to show that Wellmark had final decision-making authority. The fact that it was so heavily involved in and had the ability to effectuate the discrimination is the legal test. So I would ask this court to reverse.
Just a minute, I have one question.
Oh, of course,
Sorry,
Your
that's okay. I should have jumped in a little bit earlier. So is it your position that the discretion you allege Wellmark had, that you seem to make the argument that they were the final sayer in claims? Are you saying that the discretion they had up front, and I think you have been citing 5.13 as evidence of the discretion, is it your argument that that discretion remains not just in the formulation of a plan, but even after that, and the bottom line final answer, they have just as much say in rejecting something that the plan says they cannot cover?
It's 5.13 instead of 5.13, Your Honor. I don't know that I would go so far as to say that they have just as much say. The plain text of the MSA that I've just cited makes clear that they do have discretion. There's no appeal to the state. There's no process for the state to second-guess Wellmark in administering those claims. And we see that Wellmark had discretion to provide coverage for some gender-affirming treatment because they did so in this case.
Thank you. And
Thank
now you
Your
can give
Honor.
your summary statement if you wanted to.
Thank you, Your Honor. We would just ask that this court reverse the grant of summary judgment below so that Vrew can put his claims against Wellmark to the jury.
Thank you. The case of Vrew versus Iowa Department of Corrections et al. Is hereby submitted, and court is adjourned for the morning.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.
So in this particular case, it appears that it's a purely Iowa case being tried on Iowa law or the Iowa Civil Rights Act. And yet there was a lot of reference made to US Supreme Court decisions. With the Iowa Supreme Court, what rules the day? Are they bound by previous Iowa Supreme Court decisions only, or the reading of the Iowa statutes, or is the federal law brought in some case, or the federal Supreme Court decisions brought in some way?
So the Iowa Supreme Court, since this is under ICRA, which is an Iowa law, is first looking to the law itself. But there's this kind of principle that because the Title VII and Title IX, which are the federal laws, are very similarly written, that oftentimes the Iowa Supreme Court and Iowa courts in general are going to look to what the federal courts did, just kind of as a reference point, as a guide, because again, they're very similar, they have a very similar purpose. And if someone from the federal system has touched on this point already, or is interpreting it in a certain way, we should consider what they're doing. That said, again, the Iowa statute is what governs the interpretation of the Iowa law. So the Supreme Court will also look at its own precedent, but it's not necessarily bound by it in the same way that our court is or a district court is. The Iowa Supreme Court can change its own precedent, but it does so, doesn't do that every day.
Well, it seemed to me that they were referencing, was it a 1983 decision? So something that was decided, more than 35 years ago. Were they asking basically for a fresh view based on changing social circumstances or changes in the law?
That's the sense that I got from the oral arguments. The case that the plaintiffs were referring to, I believe, was the Summers case, which was decided many decades ago. And my sense was that the plaintiff was asking the Supreme Court to revisit that opinion and to revisit it in light of what's happened at the federal level. As you know, we have two parallel court systems in the United States. One is the federal system and one is the state system. This case is brought, as John mentioned, under state law, but the plaintiff was asking the Supreme Court to look at what's happened at the federal level and consider Summers in that light.
Since they decided to bring this action at the state level, does that preclude them from making a federal case of this as well?
I don't think it would preclude them from doing that, but I think sometimes the parties just make a choice about where they think they would have the most favorable hearing with their issues that they raise. And so I think that's the strategy that the plaintiffs followed here.
That said, if the case involves solely Iowa law, unless there's an argument that somehow Iowa law contravenes the U.S. Constitution, there's no appeal beyond the Iowa Supreme Court. So it wouldn't go up to the U.S. Supreme Court.
But they could bring something in U.S. District Court based on, I think you mentioned Title VII, which is a federal statute.
Correct.
Now, would that violate, I think Justice Apple mentioned the 2 bites of the apple. I think there was a little pun in there as well. Does that violate that whole idea of taking 2 swipes at the thing if you sue in both state court and in federal court?
It is, to some extent, they could have brought the federal claims alongside the state, because the state courts generally have jurisdiction over both the state and federal claims. So it could have brought as a claim alongside it. Without having the background knowledge completely of if a federal district court were to see now a Title VII claim and the state were to argue that this claim was already adjudicated, I guess I see that there would be differences between the Title VII claim and the ICRA claim to the extent they are interpreting different statutes. So I think that would, I believe, would be enough for the district court to say these are different claims. And while they could bring them in state court alongside this claim, they're not barred because they are a little different claims. So it's not exactly the same bite at the apple, in that it's usually the bite of the apple is more concerned with, all right, this specific claim and these specific facts have already been adjudicated. Here, if there's a different claim, it's a new claim, same facts. So I don't know if that provides a clear answer, but I believe it would be enough for a judge to, at the district level or the federal district level, to allow the claim to go forward.
So I'm not asking you to look into your crystal ball and decide what your colleagues are deciding, but what happens next? How does this process play out, and what are the implications for a decision for either, well, I guess any of the parties?
One big difference between the Supreme Court and the Court of Appeals, which is the court that Judge Tabor and I sit on, is that the Supreme Court decides all their cases as a group of 7. We have 9 members on our court, but most of our cases are decided by 3 members. That allows us to hear more cases. So what will likely happen is that they will go back into their conference room and discuss the issues that have been raised by all sides here. And they will come up with a preliminary vote as to how the justices would like to go. And one of the justices will write what's called a majority opinion. The other justices then have the opportunity to sign off on that majority opinion, or they can write what's called a dissent, saying that they disagree with all or parts of the majority opinion, or they can write what's called a special concurrence, which means that they agree with the result, but they don't necessarily agree with some of the reasoning. So those are the 3 options that the Supreme Court has. They work under a term that begins in September this month and continues until the end of June. And so their decision could come out anytime between now and June. What you can do as students is look at their website, which is, if you Google Iowa courts, you will get the website, and then you can go under Supreme Court and under opinions and find their opinion, but I cannot predict when that will be.
Let's assume that they find merit to either the state's claims or to the counterclaim about the insurance company. What would happen? I mean, it would be remanded to the trial court, or would there be automatic damages, or what happens if they make a decision that something did go amiss in the trial court?
So if the court finds merit to the state's argument and that those jury instructions were not properly given, or that there were wrong evidentiary rulings, they could order a new trial. So at that point, the jury's verdict would be taken away and the plaintiff, Mr. Brew, would have a new trial. If they agreed on the cross appeal that Wellmark should not have won as a matter of law, it might be possible for Mr. Brew to have a trial against Wellmark. And as you remember, that was one of the questions, were there separate damages? And it appears that there were some damages that got held back that they would be asking for if they did get that new trial, if they got a first trial against Wellmark. So those are kind of 2 different possible paths, I think.
So let's step back from this case. And both of you mentioned, both of the judges have mentioned that you're an intermediate court. What's the difference between the type of cases that go to the Iowa Supreme Court and go to the Court of Appeals?
Well, most appeals are actually, well, first, all appeals technically go to the Supreme Court. And then the Supreme Court decides that some cases should come down to us, so they transfer them down to us. A lot of the cases we see are areas of law that are less in dispute or applying well-settled rules and principles. So we see a lot of issues about how do you divide property in a divorce, kind of or well-established criminal issues with criminal trials, things of that nature. The Iowa Supreme Court really is seeing more kind of like the cutting edge of the law. So that's why you see so many cases that are, they're looking at other jurisdictions because they're not making necessarily too much Iowa case law on the matter. And that's really more their prerogative.
So you should be able to toot your own horn. How many cases do the Iowa Supreme Court hear in oral argument or arguments submitted versus how many cases do the Court of Appeals issue opinions on each year?
I don't know the precise number of cases that they hear in oral argument, but in terms of cases decided in a given year, we decide anywhere from 1,100 to 1,200 cases per year, and about 30% of those cases are scheduled for oral argument, maybe less than that these days. We cut back somewhat in light of the COVID pandemic. The Supreme Court decides approximately 150 cases, and my colleagues can correct me if I'm wrong about that, per year.
Yeah, maybe a little fewer, but they do exclusively the attorney disciplinary cases, so that would go into their numbers. But yeah, 100 or a few more, yeah.
I know that we're getting close to the time. I'd like to ask the young woman from Roland Story if you've got any other questions, not just about the case, but about either the process or the practice of law for our panel.
I don't think we have any right now, but.
Just wanted to give you one more bite of the apple. Is there anything that you judges or your clerks would like to end with about Constitution Day, the practice of law, the importance of rule of law in our society before we end?
Thank you so much for participating in Constitution Day. I firmly believe that these types of programs are essential to help people understand what our court system does and how we fit into the other branches of government. And so, as I said at the outset, I'm very appreciative of the Bar Association's role in helping educate young people like you before you become adults and vote about the system of government that we have in the state of Iowa.
Well, again, thank you so much for being part of this program. I believe that Marissa indicated that she was going to do some editing and put the package together that included the oral arguments as well as this panel discussion, the questions from the students, and then that new video would be loaded up to the website for other student groups to be able to view. I did get emails from at least 4 or 5 other schools that unfortunately their government classes were meeting this afternoon as opposed to in the morning. And so they are looking forward to being able to view this production at a later time. So thank you so much for your participation, both at Roland Story High School as well as there at the Iowa Judicial Building.